Good morning. Myself, Prof. Chakraborty, Assistant Professor, Department of Commerce, Darrang College. So today's video is on the law of contract. So man by nature, he is a social being and he comes in contact with a large number of different persons in different capacities. Law of contract, this is the most important and significant branch of commercial law. When such laws would have been difficult, without such laws, it would have been difficult to carry out different business transactions. The law of contract affects every person who lives in the organized society because he or she enters into contract every day. Now, as a person, we always enter into contract whether we are aware about it or we are unaware about it. Like if we drink a cup of tea or coffee, or if we hire a bus for travel purposes, if we take the credit card of a bank, and many more such transactions we conduct, it creates certain legal relations along with certain rights and obligations. So it's very necessary for us to know about the law of contract. Now, this law of contract did not exist in India earlier because it was mainly guided by transactions were mainly guided by truth. So people followed the principle of truth in doing business transactions. But during the British rule, it was felt that uh, the law of contract is very necessary, and as such, the British government, they had started they had laid down a commission, and this commission gave its report in 1866, after which the law of contract came into force on 1st September 1872. So the law of contract, this is basically a fundamental law, and as a human being, since we enter into contracts for different purposes, it's very essential to for us to know about this law. So let's get started to know about this law of contract. So first, let us know the need and objective of the law of contract. So the Indian Contract Bill, as I have already told you, it was passed by the legislature and it received its assent on 25th April 1872, and it came into force on 1st September 1872. So the primary objective of the law of contract is to identify the circumstances where we have the parties who enter into contract, they make promises and they keep the promises, and it creates a legal binding on the parties. So in order to form a contract, we actually need two parties, and these two parties must be in legal relation. If they are not in legal relation, it does not create any kind of contract. So that must be remembered, that if two parties are not in legal relation, then it is not a contract. Now, in our daily life, we enter into different kinds of contract, but all contracts do not have legal relations. So if it doesn't have legal relations, then it is not a contract at all. So the main objective of the law of contract is to identify the circumstances where promises made by the parties to a contract become legally binding on both the parties. Now let us see what are the things that are included in the law of contract. So we find that the law of contract, it contains the general principles of the law of contract, which is given under section 1 to 75, and it contains the specific contracts which are explained under section 124 to section 238. So here I would like to mention that initially we had 266 sections, but afterwards, from the law of contract, two things were eliminated. That is the law relating to sale of goods, which was eliminated in 1930, and the law of partnership, which was eliminated in 1932, because it was thought that these two topics should be dealt separately. And for this, the separate act was passed. So at present, we have two things covered under the law of contract, that is the general principles of the law of contract, and we have certain specific contracts. Specific contracts include bailment, pledge, agency, guarantee. These are all included under specific contracts. So general principles of the law of contract should be known to all of us, because this is very important part whenever we enter into any kind of contract, whether getting a book from a store or when we go for having any kind of lunch or dinner in any kind of restaurant, there also we enter into contract. So these general principles of contract must be known to all of us. So now, first of all, let us know what is contract. So as it is given in the Intent Contract Act 1872, Section 2H, it defines a contract. So it says that an agreement enforceable by law is a contract. Okay, so an agreement enforceable by law is a contract. This is a simple definition given by the law of contract. But the formation of the contract should be known to us. So how we enter into a contract? When do we enter into a contract? So actually here in the definition given under section 2H of the Indian Contract Act 1872, it is said that an agreement enforceable by law. So here we have the word agreement. So let us understand how we come to an agreement. Now in this regard, I should say that all agreements are not contracts. Only those agreements that can be enforceable by law is a contract. So let me explain to you what is the law of what is a contract with an example. So the formation of a contract actually begins when one person gives a proposal. When one person gives a proposal. Proposal, now what is proposal or offer? Proposal or offer is simply when I say that I want to sell my car. I want to sell my car for rupees 1 lakh. So this is a proposal that I give. So this is what I call a proposal. So here I am saying that I want to sell my car for rupees 1 lakh. So this is the offer I give to another person. So we all know that in a contract we have two parties. One gives the offer and the other accepts the offer. Now when I give the offer, my intention is that the other party will accept the offer. But always it may not be so. When the offer is rejected, it results into nothing. That means no agreement, no contract, nothing is formed. But when the offer gets accepted, it becomes a promise. So promise, it becomes a promise. Now I want to sell my car and somebody accepts that offer. So I promise to sell my car and the other person promises to pay the money for getting my car. So a promise of one party is exchanged for the promise of another party. So here both the parties, the first party and the second party, both are making a promise. So we call that reciprocal promises. So two promises are there in a contract. So in one contract we have two promises and these two promises are called reciprocal promises. So when one party exchanges his or her promise for the promise of the other party, this is termed as an agreement. So when two parties have exchanged their promises, then we come to an agreement. Now already I told you that all agreements do not turn into a contract. Why? Because in case I make a promise to another party that I am going for dinner with that person, and the same day I do not land up for dinner, then it is not a agreement. So all agreements cannot be a contract. So when I say that I want to sell my car for rupees 1 lakh and the other person also accepts that yes, I will purchase the car for rupees 1 lakh, then we exchange our promises, which is reciprocal promises. And here we can say that this agreement can be enforced by law. That means the promises are binding on both the parties. So I shall fulfill my promise by selling my car to the other person, and the other person shall fulfill the promise of making the payment and taking the car. So this 1 lakh is called consideration. So between the agreement that we make, the 1 lakh amount that has been decided, this is called a consideration. And we all know very well that in a contract, when two parties come to an agreement, when two parties exchange their promises, then it is not for any um, kind of freebies, or it is not any kind of barter exchange. It is a exchange in terms of certain consideration. So that consideration is the amount 1 lakh for me myself, and the card that I am selling, it is the consideration for the other person. Now we have different kinds of contracts. So some contracts are social contracts. Now social contracts can never be um, enforceable by law, but commercial contracts are always enforceable by law. So an agreement, if it can be made enforceable by the court of law, it is called a contract. So court of law means in case I do not fulfill my promise, then the other person can move to the court and sue me. Because since I have made the promise to sell my car, and if I do not give the car to the other person, then the court of law can make it legally binding on me to fulfill my promise. So now we have different examples of contracts like employment contract, partnership agreement, and many more. So in the Indian Contract Act 1872, we have the different definitions given. Like in section 2A, we have the definition of offer, because offer is a very important part when we go for making an agreement. Without a offer, without a valid offer, contract is not possible, agreement is not possible. So section 2A defines an offer. Section 2B, it defines a promise. So what is a promise? If we see the definition given in section B, it will be clear to us. Section 2C of Indian Contract Act defines the promisor and promisee. Because in any kind of contract, you have two parties. One is the promisor and the other is the promisee. Section 2D of the Indian Contract Act defines consideration. So already I have told that consideration means the exchange of things that we do. Like when I say that I am selling my car, so the car is a consideration for the other party, and the 1 lakh rupee is a consideration for myself. Now section 2E, it defines an agreement. Section 2F of Indian Contract Act, it defines reciprocal promises, and section 2G of the Indian Contract Act defines a void agreement. Void agreement means the agreement that doesn't have any kind of legal implications. So now moving on to the next slide, that is all contracts are agreements, but all agreements are not contracts. So the above statement, it highlights two significant things: a contract and an agreement. So a contract, in order to be a contract, an agreement must be enforceable by law. So agreements that are enforceable by law is a contract, and agreements that are not enforceable by law is not a contract. So many times we confuse ourselves. We know what are agreements. We often use the word agreement, but we think that agreements are always contracts, but it is not so. Agreements are not always contracts. Agreements which are only enforceable by law means it creates a legal implication, legal binding on both the parties to fulfill their promises. So if I agree to sell my car, the other party also agrees to purchase the car in lieu of a consideration. So I need to fulfill my promise by selling my car, by handing over the car to the other person, and the other person should also be paying the consideration to purchase the car. So if I have done my obligation, other person should also fulfill his or her promise. Then only it becomes a proper agreement. And these agreements can be sued in case one party is unable to fulfill their promise. then in such cases we find that the other party has the choice of moving towards the court of law to get the terms and conditions of the contract fulfilled. So both the parties have legal obligations, and then only agreements can be a contract. So it is very clear that all contracts are agreements, but all agreements are not contracts. Now, Section 10 of the Indian Contract Act 1872, it describes the different essentials of a valid contract. So it says that all agreements are contracts if they are made by free consent of the parties competent to a contract for a lawful consideration and with a lawful object, and not hereby expressly declared to be void. An agreement becomes enforceable by law when it fulfills certain conditions. These conditions may be called the essentials of a contract. Now, valid contract. This concept, valid contract means it has certain essentials. It has certain important qualities for which it is called a valid contract. So, valid contract essentials are given under Section 10. So, let us see what are the essentials of a valid contract. So first essential is there must be an offer and acceptance. So already we have seen that one person places the offer with the intention that the other party will accept the offer. So an offer must be made and acceptance must be given. Now when a person makes the offer, he must be very specific about the offer. What kind of offer he is making? He must be very specific about it. Like if I say that I am selling my car for rupees 1 lakh. Now, this is an offer, but to be a valid offer, I must be mentioning about the specification of the car. So, I may be having 10 cars. Out of the 10 cars, which car I am selling? This thing must be specific in case of an offer. If it is not specific, then we cannot consider it to be a valid offer. So, whenever offer is given, offer must be communicated to the other person. If I think that the other person knows about my car, the other person is aware about that, about my selling the car, then I am wrong. So whenever an offer is made, offer should be communicated properly and offer should be given in a very, very specific manner. Same way, the acceptance of the offer is equally important. So if any person wants to purchase the car, my red car or black car, I must be specific about that, and the other person will also know properly that which car he is willing to purchase. So he may be interested in purchasing the red car, but if I sell the black car, he may not be interested. So I should be very specific in giving the offer, and the other person then communicate the acceptance in a proper way. So acceptance means it can be given orally, it can be given in a written way. Silence cannot be taken as acceptance. Whether the other person wants to purchase a car or not, that must be communicated properly by him or her. So, in case of a valid contract, the first essential is you must give a proper offer or proposal, and the other person must also give a proper acceptance to the offer. Second point is the consent of the parties must be free and genuine. So, consent means here we are talking about free consent. Free consent, when do you say a consent is free? When the consent is said to be free when the person is not under any kind of undue influence, when the person is not being intimidated, or when the person is not under the influence of any coercion. So there must not be any kind of force or pressure on the person to accept the offer. It must be free and it must be genuinely given. Many times we have seen in Bollywood movies that at gunpoint people are told to sign on certain documents, and ultimately it is said that the property is mine or so and so things are mine. But this cannot be a contract, because when you put a person on a gunpoint, he is under a pressure, and under pressure it is not a valid contract. So whenever contract is made, whenever the agreement is made in the first stage, then it is very essential that both the parties should be freely giving their offer and freely accepting the offer. So consent of the parties must be free and it must be genuine one. Third point is the parties must intend to create legal relationship. So creating a legal relationship, creating a legal obligation is very essential in case of contract, because agreements turn into contract only when there is legal relationship. If there is no intention of the parties to create legal relationship, it does not result in any kind of contract. Fourth point is the parties must be competent to contract. Now, who are the parties who are competent to contract? So, all of us know very well that competent to contract means you must be a person who is very well aware, who has the rationality to think what is right and wrong. And that means people who are major. Major means 18 years or above, they are competent to enter into a contract. Persons who have a sound mind, they can enter into contract. So people who do not have the balance of mind, who cannot take proper decisions, they cannot enter into a contract. So competency of the party is very important in case of contract. So we must judge the competency of a party before entering into a contract. Otherwise, a contract will not be a valid contract. Next is there must be lawful consideration on both sides. So lawful consideration means this is not, contract is not any kind of barter system. Contract is not any kind of exchange of freebies. Contract is about exchange of certain things between two parties. So I fulfill my promise, another person also fulfills my promise. So if I am willing to sell my car, another person is also willing to purchase the car for a certain amount. So the amount that is given to me, that is my consideration. Amount given, the car that I sell to the other person is the consideration for the other one. Lawful consideration is very important because many times people enter into agreements for unlawful activities also, but that cannot be sued in the court of law. So agreements relating to any kind of theft, dacoity, murder, etc., this cannot be legal contract. This cannot be a valid contract because the very base of the contract is a illegal one. Next point is there must be a lawful object. Object means the subject matter of the contract. So the subject matter of the contract is very important. As I told you just now that our legal system recognizes certain matters which are lawful and certain matters which are unlawful. So lawful object is lawful subject matter is very important. Lawful subject matter means it should not be forbidden by law, means matters which are not forbidden by law, matters which are not any fraudulent, matters that means subject matter that does not involve the injury of any person's life or property. So if the court considers, if the court of the law considers certain subject matter to be immoral or opposed to public policy, then it becomes unlawful. So we must be very careful that when we enter into a contract, our subject matter is lawful and the subject matter is lawful and the consideration also is a lawful one. Then next is the in case of a valid contract, we find that the terms and conditions of the contract must be clear. So always in case of a contract, there must be very specific, in specific terms it must be mentioned the terms and conditions of the contract so that it is clear to both the parties. So whenever I am giving the offer to another person, I must be very specific in giving the offer so that the other person doesn't develop any kind of misunderstanding. Similarly, the other person, when he communicates the acceptance, he must also be careful about it. He must also be clear about it. So the terms and conditions of the contract should be clear to both the parties so that both the parties can fulfill their promises without any hesitation, without any doubt. Next point is the performance must not be impossible. So an agreement to do an act which is impossible in itself cannot be enforced by the court of law. Impossible in itself means when the parties to an agreement agree upon to perform an impossible act. Like if somebody tells me that I can uh, I can bring certain stars from the sky, I for which you can pay me 1 lakh. These acts are not possible at all. We all know about it. These acts are not possible. If somebody tells me that I can give me 10 rupees, I will make it 1 lakh within 7 days. So we all very know that these acts are not possible at all. So performance of those kind of things which are possible comes under a valid contract, and those which are impossible do not come under the scope of valid contract. And last but not the least, all legal formalities, if any, must be compiled. Now, legal formalities in case of a contract, there are many kinds of legal formalities, like it is said that agreement must be in writing, then the agreement must be in a prescribed form, the agreement must be attested, the agreement must be registered, and uh, there must be some, in certain cases, there is requirement of stamp duty also. So, depending upon the nature of the contract and the law to which such a contract should abide to, the legal formalities need to be fulfilled, and the legal formalities need to be complied by both the parties. Then only a contract becomes a valid one. So, I hope that the concept of contract is very clear to all, and the essentials of a contract, of a valid contract that is given under section 10 should be always remembered whenever we enter into any kind of contract. Thank you.